To get started, we're going to talk today about land trusts. And we'll talk about today the definition of a land trust. We'll talk about the basic formalities to follow when forming a land trust. We'll talk about how to form a land trust. Of course, the benefits of titling real property, real estate to land trust. Why a land trust proves no asset protection benefit on its own. I get people who call me all the time and, say they've set up an asset protection vehicle and they're talking about a land trust, and, really that's not the case unless it's done correctly. So we'll talk about that. We'll also talk about how to keep your land trust protected and still reap the privacy benefits. And we'll also talk about how to capitalize, the full benefit of your land trust. So just, some background information. What is asset protection? The definition that I give for asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors. So what I tell my clients is, asset protection is really protecting every single thing that you own from everyone, every time. It might be as simple as your checking, savings, stocks, bonds, brokerage, money market accounts. It might be your retirement accounts, your real estate, your primary home, investment property. It might be shares in a corporation or membership interest in an LLC. Could even be intellectual property like phone numbers, domain names, corporate goodwill. And, we want to protect it against any financial threat. So in today's day and age, lawsuits, car accidents, slip and falls, creditors, judgments, divorce. We want to protect every single thing that you worked so hard for so you can go to sleep at night knowing, God forbid, if something happened the next day, you won't lose your entire life savings. And, a lot of people say, well, do I have enough assets to protect? Is asset protection only for the wealthy? And the answer is absolutely not. Everybody has enough assets to warrant asset protection. I don't care how little you think you have. What if you lost the little that you think you have? Everybody needs asset protection. And, the example I always like to give is take one of my professional athletes. If they get sued for $5 million, but it's $50 million in the bank, well, they're not going to be happy, but they still have $45 million left. Take the average person who saved up a couple $100,000 over their lifetime. If they get sued for $1 million, they're going to be wiped out. So, the less you have, actually, the more protection you need. And a lot of people also say, well, what if I already have an asset protection plan? If you already have an asset protection plan, I think that's great. But, definitely make sure that you have it checked out by an asset protection attorney. A lot of people come into my office thinking they have asset protection plans, and really they're estate plans. They might walk in with a trust, a living trust, a domestic revocable living trust, which I think is great for estate planning, but doesn't give any asset protection benefit. So certainly have it reviewed. A lot of people say, well, why do I need asset protection? And I always like to show this slide. There's a little cute cartoon in the top right-hand corner, and it's actually two lawyers talking, and one says, I say sue, the other one says anyone in particular. And, I always get a couple laughs when I show this, but, unfortunately, this is the truth. Just like we're smart enough today to get together and learn from one another, the lawyers are getting together, and they're figuring out, who are we going to sue next? Is it going to be the business owners, the doctors, the car manufacturers, the financial advisors? Who's going to be next? There's over 100 million lawsuits every single year, and that number's only growing. Lawsuits are truly becoming today's next biggest business. There's literally a lawyer on every single corner that you can go hire for free to sue somebody, because the majority of the time they'll take your case on a contingency fee basis, which means you don't have to pay them anything, and they just get a percentage of the fees if you win. So it doesn't really cost anybody anything to do that, maybe 20, 30 minutes of their time. Meanwhile, if you have to defend the case, it could cost you tens, if not hundreds of thousands of dollars, even if you win the case. There's a 1 in 4 chance you will be sued in the next 12 months. The average person and company is sued 5 times over their lifetime. So if you have an S-Corp, well, on average, you're sued 5 times over your lifetime, and on average, the S-Corp sued 5 times over their lifetime. No difference with an LLC or any other type of business entity. Now, these are just the averages. I have clients that have never been sued. I have clients that get sued 5 times a month. It just depends what type of business you're in, how many employees you have, and things of that nature. There's a 50% chance of divorce, and a lawsuit can cost you tens of thousands of dollars, even if you win the case. And again, unfortunately in our legal system, they make it so easy to sue somebody and so inexpensive, if not free, to sue somebody, but they make it so difficult and expensive to protect yourself. So the trick is really not making money, it's keeping it. And, the challenge I give to all my business owners and to all my clients and all my doctors and professional athletes and anyone who works with us is for every 60 minutes spent making money, spend 60 seconds thinking about how to protect it. So a lot of people say, well, what about insurance? Isn't insurance enough? And, I think insurance is great. I mean, I tell all my clients, buy as much insurance as you can because it's cheap and it helps you sleep at night. But with that being said, understand that the insurance companies are a for-profit company. And if you drive down the highway, their names are usually on some pretty big buildings. And they don't get there from paying all the claims. An insurance company, a for-profit company, wants to take in as much premium as possible and pay out as little claims as possible. And about 70% of lawsuits are not covered by insurance. My father always used to say, the big print giveth, the small print taketh away. And anyone who has an insurance policy knows there's about a half a page of what's covered and about 65 pages of what's not covered. Your coverage may be inadequate. What if you have $100,000, $200,000 of coverage on your car, but you get in an accident, somebody gets paralyzed and they go to the emergency room? They could have $1 million in medical bills, and who do you think has to come out of pocket? The rest. You. Your insurance company might go bankrupt. 5, 10, 15 years ago, you guys would have told me I was crazy. But today we have banks and Fortune 500 companies going out of business. Who's to say that the insurance company won't be next? And of course, insurance doesn't cover other uninsured financial risks and divorce. So, insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. I call it the belt and suspenders approach. You need as many layers, as many firewalls, as many speed bumps as possible to make it so difficult and expensive, if not impossible, for anybody to collect against you that they don't want to sue you in the first place. 3 maxims of asset protection planning. Number 1, protect yourself before you have a problem. You don't buy car insurance after the accident. You don't buy health insurance after you get sick. And you shouldn't try and do asset protection planning after you've been sued. You really need to be proactive if you want to have a good and defensible plan. Also, start with a basic plan and add firewalls as needed. I can't tell you how many times someone will read one of my books. They bought it at the bookstore or Amazon or something like that, and they'll call me and say, I need a personal international asset protection Swiss hybrid trust, and they'll go on, and I'll have to stop them. You want to start with a very basic plan. Start with a very simple plan. Start with a very inexpensive plan. As your education grows, your plan can grow. As your assets grow, your plan can grow. But don't try and do everything at once. And most importantly, never look for one magic bullet or, one size fits all. Asset protection planning cannot be cookie cutter. Asset protection planning must be individualized and customized and tailored. What works for you might not work for me and vice versa. Everybody has different personal assets, everybody has different business assets, and everybody has different potential threats and creditors. So you really need something that's going to work for you, not for somebody else. A lot of mistakes to avoid. The 5 top mistakes to avoid. Number 1, hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. You should be able to tell every single person what you have and where it is. They just shouldn't be able to get to it. And I tell all my clients to expect at some point they're going to have to tell somebody what they have, because if they get sued and they lose, well, that creditor can sit them down for a deposition under oath or give them a financial affidavit to fill out under oath, and if they lie, they're perjuring themselves. So you got to make sure that asset protection is not about hiding or secrecy. You never want to go titling all your assets to straws. A lot of times someone will walk in my office and say, oh, don't worry, I'm being sued, but I gave everything to my best friend or my brother-in-law. What actually makes you think that your best friend or brother-in-law has less financial and legal problems as you? I can't make these stories up. I've seen times before where somebody's given all their assets to their brother-in-law, the brother-in-law gets sued, and the person suing the brother-in-law takes the client's assets. I've seen other times where the client gives everything to their best friend, the best friend gets a divorce, and the best friend's wife walks off with the assets. I mean, it's crazy. You don't want to go titling your assets to straws. No difference with titling all your assets to your spouse. We see this the most with our doctor and physician and surgeon clients. Oh, don't worry, everything's in my wife's name. Nobody's immune from a lawsuit. Nobody gets up in the morning and expects to be sued. Your wife can just as easily get in a car accident taking the kids to soccer practice. There could be a divorce. So don't go titling everything to your spouse. You never want to commit a fraudulent transfer, and fraudulent transfer deals with transferring assets out of your name for less than fair market value after there's a present or potential lawsuit. So again, you don't want to do that. This goes back to what we discussed about being proactive. Asset protection planning, whether it be for personal or business, should all be proactive planning. Defensive planning should not be done after you've been sued. And of course, most importantly, you never want to break any laws. Our law firm does both domestic and international asset protection, and you always need to make sure that everything you're doing is legal and ethical. You always need to make sure that you're following all the reporting requirements with the IRS, the Treasury Department, your state, et cetera, et cetera. You always got to make sure that what you do is on the up and up. So, what is a land trust? Well, a land trust is really just a grantor trust, which is a trust between, three parties. And, any trust really has these three parties. You have the grantor or settlor. Some say grantor, some say settlor, and that's the person setting up the trust. You then have the trustee, and that's the person who holds legal title to whatever asset is in the trust. And then you have the beneficiary, and that's, of course, whoever benefits from the trust. So in any type of trust, including a land trust, you always have three parties: the settlor or grantor, the person starting the trust; the trustee, the one who holds legal title to the asset; and the beneficiary, the one who benefits from the asset. And, the grantor essentially creates the trust, and the trustee holds that legal title to the property, because in this case we're talking about a land trust, so there's real estate in it. And they do it through the trust, and they actually control the assets. And the beneficiary really just holds the use and enjoyment of the asset within the trust. So, the three parties, you have the person setting up the trust, the person who kind of watches over the trust and holds legal title, and then you have the beneficiary, the person who benefits from the trust. So how do you form a land trust? First, of course, you need a customized trust agreement. And, whenever you're putting that trust agreement together, you always want to make sure that you put as many asset protection and anti-creditor clauses in there as possible. Your trust is only as protective as the agreement. And the fact that you get to individualize and customize it, why not put everything in there that's going to be good for you, God forbid anything happens, and anything in there that's going to be bad for a potential creditor. You also have to choose the trustee and the beneficiary. So the trustee might be a family member, it might be a lawyer, it might be an advisor, and who the beneficiaries might be: your spouse, your children, friends, but you'll certainly have to pick who's going to be involved in the trust. And the investor can buy the property in the trust, or they can deed it directly into the land trust. I always advise buying the property, if you're going to use a land trust, directly in the trust. And the reason being is, if you buy the property in your personal name and then you deed it to the land trust, well, they can always look up who owned the property before. And, by doing so, they might be able to figure out, based on the sale price, that, you owned the property and then you just merely transferred it to the land trust. So if possible, if you're going to use a land trust, and a lot of times there's a lot better entities out there besides land trusts. I think that people give more credit to land trusts than they actually deserve. But if you are going to use one, use it correctly and deed the property in directly when you purchase the property. So, what are the benefits of titling, real property to a land trust? Number one, and the most important thing that a land trust offers, is the privacy. When the trust is recording, the third-party trustee will be listed rather than the investor. So when you put real estate in the trust, it states that the real estate is owned by the trust. And it shows the trustee's name and it shows the trust name, but it does not show the beneficiary. So it does give you a great deal of privacy. If someone did an asset search, and I just use a personal injury attorney as an example, but really if anybody does an asset search, it wouldn't come up because you don't own the property. It's owned by the trust, which the law looks as separate and apart from you. And, if it's used in conjunction with other entities like asset protection LLCs and asset protection limited partnerships, et cetera, then it can provide, the investor or the owner, a great deal of asset protection. And we'll talk on that a little bit later. But if it's not used in conjunction with the LLCs and limited partnerships, there is no asset protection benefit. And that's one of the biggest misconceptions I see. People think that they have a land trust and they have asset protection, and they don't. They have privacy, but not asset protection. So let's kind of talk about that for a little bit. Why doesn't the land trust provide asset protection on their own? Well, number one, there's no uniformity between states. But states without the land trust statutes, they'll recognize them as grantor trusts. So, that's number one. Most importantly, if you're the beneficiary, then the beneficiary of the trust receives obviously all the benefits associated with the real estate and property in the trust, but also all the liabilities associated with the property flow down to that beneficiary. What that means is that if, God forbid, anyone ever gets injured on the property and they go after suing the trust, they might be able to go after the beneficiary. And if you're the beneficiary as an individual, they might be able to go after you. And again, a lot of this depends just how the trust is set up and, what terms and clauses are in the trust agreement. If the investor holds the beneficial interest, a plaintiff will seek recovery against the investor individually, and that is the absolute most important. If you set up a land trust and you're the beneficiary, well, yeah, you don't own the piece of real estate. It's owned by the land trust. However, you have the ability and the benefit of that trust because you're the beneficiary. So if you're the beneficiary of a land trust as an individual and somebody sues you, well, they can take any assets you have. And one of the assets you have is being the beneficiary to the land trust. So somebody can actually take that beneficial ownership, which gives you absolutely no asset protection. And, of course, if the investor is sued individually, their trust property is at risk. This is pretty much what we talked about above. Again, if you are the beneficiary of the land trust and you're sued personally, let's say you get in a car accident, divorce, someone slips and falls, you're sued by a customer, a supplier, whatever it may be, that is an asset. And the beneficial interest that you own in that trust is an asset that a creditor can go after. So, again, yes, it does give you privacy. No, it does not give you asset protection. So how do you get asset protection with a land trust? Well, you have to use the land trust in conjunction with other protective entities. And we talked about this in previous slides. You can have the Asset Protection LLC, the Asset Protection Limited Partnership, etc. And, after the deed has been filed and the title is vested into the trust, the beneficiary can actually transfer his or her beneficial interest, to the trust. Now, again, like we talked about before, although you can transfer your beneficial interest to the trust, I always suggest having the Asset Protection LLC or the Asset Protection Limited Partnership be the beneficial owner of the trust from the beginning, from when it's set up. That way there's no fraudulent transfer issues and everything's very clean. But, the investor can assign their interest to the LLC or the LP, and thus the LLC or the LP is the beneficial owner and has the beneficial interest. And, of course, the liability exposure is contained in the LLC. So what this means is if somebody gets hurt on the property, well, who's the beneficial owner? It's some sort of protective entity, whether it be an LLC, a limited partnership. There's dozens of types of entities. So, there's no personal liability. But even more important, let's say you get sued personally. Well, unlike in the past slide where you owned the beneficial interest to the land trust, here the beneficial interest is owned by some sort of protective entity like an LLC or a limited partnership. Well, in that case, if you're sued personally, since you don't own the beneficial interest, nobody can go after it. And if those LLCs or limited partnerships are set up correctly from an asset protection point of view, they're going to shield and firewall any beneficial interest and ownership that you have in this land trust against any creditors. So if you are going to use the land trust, to get the best of both worlds, instead of being the beneficial owner as an individual, have an LLC or a limited partnership, of course, with set up correctly from an asset protection point of view, be the beneficial owner. That way you have privacy and asset protection, intertwined into one, rather than just the privacy but no protection. And, why your land trust is protected when the beneficial is a corporate entity is because the corporate entity, again, be it an LLC or limited partnership or any type of entity, isolates the land trust from the investor personally. Thus, the investor is sued personally. The LLC will shield their land trust from being exposed to the claim because, again, they no longer own it and, they're not the beneficial owner. If harm is associated with the property and the land trust arises, the liability is contained within the LLC or protective entity, thus, of course, shielding the individual investor from the claim. So again, if you are, as an individual, the beneficiary, you could be held liable for things that happen on the property, depending on how the trust is set up. Your beneficial ownership and interest can also be taken by a personal creditor of yours. However, if you set up some sort of protective entity to own it, then you're not going to have these problems, which certainly I recommend. And again, the land trust is not the the best thing to use all the time, but if you're going to use it, certainly you want to make sure that you use it correctly. You also want to make sure it capitalizes on the full benefits of your land trust. The land trust provides the investor with privacy. As we talked about, if you use it in conjunction with the LLC or the limited partnership, you not only get the privacy, but you get the added asset protection. And investors that are subject to a personal claim are separated, from their LLC, which encompasses the land trust. So again, if you're going to do it, just make sure you use it properly. But a lot of times, to be honest, there's easier, less expensive, and more protective things that you could do to protect real estate rather than using the land trust. But if you're going to use the land trust, definitely use it correctly.